Welcome everyone to the first Pett Franklin webinar. Today's topic is the subject of shares for rights and other related matters. Specifically, we're going to be looking in the first part of today's presentation on the rules under the new regime for shares for rights, and then we're going to look at some of the potential applications of shares for rights. After which we will mention a few of the possible alternative arrangements as well. But before we deal with the actual content of the webinar, there are some practical admin matters I would like to mention. First of all, the opportunity to raise questions as we proceed is there through the webinar system. We won't be able to answer them as we go along, but hopefully we may be able to deal with them at the end. If we can't deal with your particular question at the end, we will respond to you specifically. The slides will be available. If you want to have a copy of them, what you need to do is to email me. That's william.franklin@pettfranklin.com, and I'll send you a copy of the slides. My email address will appear again later in the webinar, and you can always go to our website for details. We'll also have available a booklet on the new shares for rights, and a free copy of that will also be available on request. There will also be an opportunity at the end for the provision of feedback. We'll be very grateful if you could complete that, because obviously this is our first webinar and it will be very useful to know what you think. So, we are a multidisciplinary legal firm. We started business back in September 2009. We specialise in tax and legal accounting issues associated primarily with share schemes, so that includes design as well, valuation, accounting, and we also help people run their schemes if need be. David, as you may well know, is the principal writer of the leading textbook on the subject and has been retained by the government to help with the drafting of model documentation very recently. Very shortly, we're going to be joined by a third partner, someone who is currently a Big Four partner in one of our competitors. So that's an exciting development. But now I'd like to hand over to David, who's going to go through the details of shares for rights.
Good morning, everybody. It was on 8th October last year that George Osborne, addressing the Tory Party conference here in Birmingham, first announced this new policy of allowing companies the opportunity to invite employees to forego certain key statutory employment rights in exchange for an issue of new shares in their company. The policy was originally greeted with some scepticism, and indeed, as part of a public consultation later that month by the Department for Biz, out of 209 responses, it was reported that only 5 were positive. Indeed, the legislation, when introduced into Parliament, had a rocky road, and it was only a few hours after the Chancellor sat down from giving his budget speech last year that the House of Lords threw out the legislation. As a result of a horse trade and the introduction of certain additional safeguards for employees, the legislation finally passed and received royal assent, and is to be found in both the Employment Rights Act 1996, amendments made to that by the Growth and Infrastructure Act 2013, and as regards the tax treatment in the Taxes Act and in National Insurance regulations. And all these new provisions take effect from 1st September this year. So what are the key features? Well, the idea is that the employee is issued with fully paid shares in either his employer company, or if that's part of a group, then a parent undertaking, in effect the holding company of the employer. Those shares must be worth at least £2,000 after taking account of any restrictions. But they must be issued for no consideration other than merely the fact that the employee is entering into the employee shareholder agreement itself. For tax purposes, the employee is to be treated as paying £2,000, even though he in fact gives no consideration. So in effect, the first £2,000 worth of shares issued to him is exempt from income tax and national insurance contributions. Furthermore, insofar as the initial value of the shares, this time ignoring any restrictions, so this is the unrestricted market value of the shares, does not exceed £50,000, then any gain on first sale of the employee shareholder shares by the employee is completely free of capital gains tax. So in many respects, this is an improvement on the relief granted for EMI share options, where the gain, the growth in market value of the shares, is charged to capital gains tax at these days a reduced rate of 10%, taking account of the entrepreneur's relief, because in this case the gain is entirely free of capital gains tax. The employee has to forego certain key statutory employment rights, and I'll come on in just a second to what those are. And there must be a written employee shareholder agreement. Furthermore, before that agreement becomes effective, the employee must receive independent advice paid for by the employer, and there must be a 7-day cooling off period in which the employee has the option to determine that he does not wish to proceed with the agreement. I said that the shares can be in either the employer company or a parent undertaking of the employer company. The key point here is that the issuing company does not need to be independent. You'll recall that in most other cases of favoured tax treatment for employee share schemes, the shares must be in an independent company. That's not the case here, and therefore it may be of particular attraction to, for example, private equity-backed companies which are perhaps under the control of the private equity fund. There's no exemption from either income tax or capital gains tax if the employee has or is deemed to have a material interest in the company. And for these purposes, a material interest is 25% of the voting rights. If it's a close company, then there's an additional requirement that the employee must not have be entitled to 25% of the assets on a distribution or winding up of the company. And not only must he not have a material interest at the time the shares are acquired, but furthermore, he must not have had a material interest at any time within 1 year before the issue of the employee shareholder shares. So what are the rights that the employee gives up when entering into this agreement? Well, the principal rights given up are the right not to be unfairly dismissed and the right to statutory redundancy pay. The right not to be unfairly dismissed is not entirely comprehensive because the employee will, in any event, retain the right not to be unfairly dismissed on grounds of discrimination or health and safety. And furthermore, the employee has the right not to be subjected to a detriment by the employer on the ground that he simply refused to accept an offer to become an employee shareholder. There are other more minor rights that are given up. For example, the statutory right to request flexible working and the right to request study leave or training. And furthermore, there are extended periods of notice to be given to an employer if the employee intends to return from maternity, additional paternity or adoption leave. But for most practical purposes, the principal rights given up are not to be unfairly dismissed and the right to statutory redundancy pay. Curiously, perhaps, these rights which are given up could, in theory, be reinstated by way of contractual agreement between the employee and the employer. But remember that if they are reinstated by way of contract, then those rights would only be enforceable on a claim for breach of the employment contract. And so, in effect, the remedy could only be sourced through the courts, not the tribunal, and without the benefit of the minimum statutory awards. So what are the advantages of this arrangement? Well, within the £50,000 limit that I described, the gain is completely free of capital gains tax, and there's flexibility in that the shares can be restricted or of a special class. But insofar as they are subject to any special restrictions, this will, of course, reduce the actual market value of the shares, and therefore a greater number of shares will be needed to be issued in order to ensure that the employee first acquires a minimum £2,000 worth of value in the shares. The shares can be in a subsidiary company, again rather more flexible than in the case of EMI share options or other revenue approved schemes. And they can be offered on a discretionary basis to selected employees. The disadvantages, well, the principal one of course is that from the point of view of the employee, he's giving up potentially very valuable statutory employment rights. And I've had feedback from one or two clients that this would put them in a moral dilemma if they were looking to invite more junior employees to enter this situation, and they feel that perhaps it is not appropriate for an employer to entice an employee to forego such valuable rights for the uncertainties of shares in the company, the value of which could of course go down as well as up. There's also the disadvantage of the upfront tax charge. We've said that the first £2,000 worth of value is tax-free, but any value in the shares above that £2,000 is subject to income tax, and if the shares are readily convertible assets, national insurance contributions, both employers and employees. Unlike unapproved share schemes, at least the revenue will agree in advance what is the market value of the shares for these purposes, so that it's not an entirely unquantified risk attached to the potential liability for tax on acquisition. The limit for the CGT relief, £50,000, is of course much lower than the £250,000 limit on the grant of EMI share options. A further disadvantage, and this is a technical one, the shares must be newly issued as fully paid shares. So you cannot, for example, use shares that are presently held in an employee's trust. And furthermore, the shares must be issued for no consideration other than that of giving up the employment rights and entering into the agreement. And this presents a number of company law problems, which we'll come back to in a few minutes. Insofar as there is a charge to income tax and NICs because the initial actual market value of the shares exceeds £2,000, then there's the question for discussion with the employee as to how that is to be funded. Is it, for example, appropriate for the employer company to pay an additional cash bonus of an amount which, after deduction of tax, covers the tax and NICs due on the value of the shares acquired as employee shareholder shares? It's very important to ensure that the process for entering into the agreement is strictly abided by. Why? Because it's important from the employer's point of view to ensure that there's no risk of a mis-selling claim or a claim before the tribunal that actually these were not employee shareholder shares simply because the company had not ticked all the boxes for complying with the requirements for entering into the agreement. There was, for example, no 7-day cooling off period, or the employee was not properly advised as to the rights he was giving up or the rights and restrictions attaching to the shares. This is very much a George Osborne proposal, and I don't think there's as yet any guarantee that this arrangement would necessarily survive a change of government. There was obviously no cross-party support as it was passing through Parliament, and we understand that Labour has indicated that it might well cancel the scheme going forward. Turning back to the tax treatment, as a general rule, of course, when an employee acquires shares which are employment-related securities, then income tax is charged at the time of receipt of those shares on their value at the time of acquisition. This is subject to numerous reliefs and exceptions for Inland Revenue approved share options, CSOP options, EMI share options, share incentive plans, and if the shares are forfeitable securities, then unless an election is made, the tax charge on acquisition is deferred until the risk of forfeiture falls away. This is another example of such a relief and should be judged and weighed in the balance against that background. It's very important to ensure that the shares which are acquired by the employee have an actual market value of at least £2,000, not just because of the tax requirements, but because if the shares are not worth at least £2,000, then they are not employee shareholder shares, and the agreement falls to the ground. As I've said, the employee is treated as paying £2,000, so the first £2,000 is free of tax, and any excess is subject to tax under the normal rules. Typically, the shares acquired will be restricted securities, and therefore it may well be appropriate for the employer and employee to enter into a Section 431 tax election so that the amount of tax charged on acquisition is by reference to their unrestricted market value. By doing so, this protects against future charges to income tax when any restrictions fall away or the shares are sold. If the shares are readily convertible assets, then in accordance with normal rules, the income tax due on acquisition will be to be accounted for under PAYE, and there will be charges to NICs. Insofar as the amount due under PAYE is not made good by the employee within 90 days after the acquisition, then there will be a further penal tax charge on the part of the employee. So arrangements must be in place to ensure that the tax due will be paid by the employee within that 90-day period. The legislation does suggest that the shares can be acquired as employee shareholder shares through the grant and exercise of a share option. I think this is more for technical reasons to ensure that the legislation and the reliefs all tie together. And the question is, well, is it practicable to use the grant and exercise of share options, perhaps EMI share options, as a way of delivering these shares? Of course, it would have to be a nil-cost option, and there's always the risk that at the time it was exercised, the value of the shares had fallen below the £2,000 threshold. I think in practice, the complexity of using options to deliver these shares far outweighs any convenience or marginal advantage to the company. So I rather suspect that that is not a mechanism that will be used if companies wish to take up this arrangement at all. Note that the individual must be an employee, quite an obvious point, but the relief will not, for example, extend to partners or to consultants of the company. I know there has been a move and some have lobbied in favour of extending it to consultants and the self-employed, but that is not the case at the moment. I said that no consideration can be given for the shares other than entering into the employee shareholder agreement. Care must be taken to ensure that the employee is not entering into any undertakings or agreement to restrict his exercise of rights attaching to the shares, because that may well be treated as additional consideration, and again the shares would not qualify as employee shareholder shares. I said that the employee must not have or have had within 1 year a material interest. In applying this test, we also look to the holdings of persons connected with the employee, and for these purposes that includes brothers, sisters, lineal descendants, business partners and of the employee. So one has to look carefully to ensure that the employee does not from the outset already hold a material interest in the company. Relief from corporation tax is available under normal rules to the employer company for the value of the shares that are issued, provided all the other normal requirements set out in the Corporation Taxes Act 2009 are then satisfied. But note that that relief under normal rules is available only for an acquisition of ordinary shares in an independent company. So if one is, in this case, using shares in a company under the control of another company, then that CT relief will not then be available. So you cannot use unlisted shares in a subsidiary company and expect to get corporation tax relief in those circumstances. Turning then to the capital gains tax relief, well, relief from capital gains tax is given on the first disposal by the employee of the shares. And note that it's only relief from capital gains tax. There is no protection against the anti-avoidance charges to income tax that could still arise if, for example, the employee subsequently sells shares for more than their market value, so as to give rise to a charge to tax as earned income under Chapter 3D, Part 7 of ITPA. Or conceivably, if the shares are sold back to the company and the employee retains other shares in the company, if it's a close company, there could even be a charge under the transactions in securities rules in roundabout Section 700 of the Income Tax Act. And in that case, the consideration received would be deemed to be a dividend. The relief operates by way of an exemption from CGT on gains realised on shares acquired with a value up to £50,000 on acquisition, but there's no cap or limit on the value of the shares which qualify for this relief at the time they are disposed of. If there's an acquisition of employee shareholder shares with a value of more than £50,000, then there are pro-rating provisions to ensure that it's only the first £50,000 worth of shares acquired which benefit from that relief. And of course the normal CGT reliefs will apply in relation to that excess. There'll be a deduction for the base cost of acquiring the assets, this being the market value of the shares at the time of acquisition, less the £2,000 treated as paid for them, and the annual CGT exemption for each individual would then be available. If no other gains are realised by the employee and their spouse, with the employee shareholder shares being transferred to the spouse and the spouse disposing of them, then the original shares would need to increase in value during the period of ownership by 1,000% before any capital gains tax is payable. If the employee dies, then there's the normal uplift in base cost to the date of death. There's no further relief for gains accruing in the hands of the personal representatives. This is because of the requirement that the relief is only given for the first disposal by the employee. It doesn't extend to a disposal by his PRs after death. There's no loss of the CGT relief if the employment has ceased or if the employee shareholder agreement has come to an end by agreement. It should be noted that there's one other very valuable relief. The general rule is that if a shareholder sells shares back to the issuing company, either for cancellation or to be held in treasury, then the proceeds received above the amount subscribed, capital and premium, is taxed as dividend income, not as capital gain, unless certain requirements are met, including in particular the fact that there has to be a disposal of substantially all of the shares and the shares have to have been held for 5 years. Now that would be a trap here, but the government recognised this and special relief is given so that if after the employee has left he sells back the shares to the issuing company, then there is specific exemption from that dividend tax treatment. But note that is only if the shares are sold back after the employee has left the company and is no longer an employee or director of that or any associated company. So there is still a pitfall if the employee sells shares back to the company, which he's held for less than 5 years, at a time when he remains an employee of the company. Other points relating to the CGT relief: there are rules which require employee shareholder shares to be separately pooled for capital gains tax purposes. And if shares of the same class are sold on the same day, some of which are employee shareholder shares but others are not, then the employee can choose to identify which type are disposed of and therefore can decide whether to claim the CGT relief sooner rather than later. In terms of the acquisition of the shares, his disposal of his statutory employment rights is taken to have a nil value. It should also be noted that the Secretary of State has power to restrict the terms of any contract or arrangement whereby the employee might be obliged to sell back shares on leaving, the typical good, bad leaver provisions. These might be contained in Articles of Association or in the terms of the employee shareholder agreement itself. As yet, no regulations have been published on this point. Valuation is key, and the Revenue has set up a procedure whereby they will agree the market value of the shares to be issued in advance. This is very valuable because for many private companies it allows a so-called toe in the water exercise to enable them to ascertain the market value of the shares for tax purposes. And although the agreement by the Shares Valuation Office will only hold good for the purposes of this arrangement, it will nevertheless give a good indication to such companies of how the Revenue would view the submission of a valuation report for other purposes. The Revenue has issued guidance, and I've put links on the slides, and have geared up in the sense that we understand that they've increased their staffing levels to take account of what they might be anticipating as a flood of applications for valuations for these purposes. The guidance is found in two places, and I've given both links on the slides. Turning then to the company law concerns I first mentioned, the only consideration which can be given for the acquisition of the shares is that of entering into the employee shareholder agreement. The shares must be newly issued, or they can be issued out of Treasury, but they cannot be existing shares held by an employee trust. Now that raises a problem. Shares cannot be issued at a discount to their par value, so how is the nominal or par value of the shares to be paid up? Well, one possibility is to use distributable reserves, but that typically requires a special resolution of shareholders or a change to the Articles of Association and an express authorization to capitalize reserves and apply them in paying up the par value of the shares to be issued. In most cases that will be impracticable simply because it will require substantive changes to the Articles of Association and may impact upon existing shareholders' agreements. If it's a non-UK company, then of course it won't be subject to UK corporate legal requirements, and this problem may be sidestepped. One answer is to arrange for the payment of the subscription price by a third party. If it's the employer company and the employer and the shares are to be issued by its holding company, then a simple answer may be for the employer company to simply pay up to the holding company an amount equal to the nominal or par value. If the par value of the shares is to be paid by a third party, such as an employee trust, then beware. That may give rise to possible penal tax charges under the disguised remuneration rules. Some have asserted that entering into the employee shareholder agreement amounts to payment in kind or money's worth, which satisfies the requirements in the Companies Act that the nominal value be paid up. But I would query, is there a payment in kind when there is nothing which can in fact be turned to pecuniary account? There's no case law on this particular point, and so it's a matter of judgment. I suppose one could ask who's interested in challenging it in the case of a private company. In the case of a public company, this would give rise to the need for an independent valuation of the consideration given for the issue of the shares in the form of the surrender of the employment rights. You remember that under the Companies Act, it's a requirement that in the case of a public company, anything other than a cash consideration for the issue of shares must be subject to an independent valuation. How on earth does one value the giving up of the statutory employment rights? Is this practical? I suspect not for most public companies, and therefore they will need either to use shares issued out of Treasury or, in a group situation, have the subsidiary pay up to the holding company an amount equal to the par value. Remember that private companies can, of course, now hold shares in Treasury and may use them for this purpose. Some other pitfalls. Beware the drafting of the employee shareholder agreement. It is open to the parties to include in that additional restrictions on shares if those restrictions are not already in the Articles of Association. For example, restrictions on voting rights or provisions relating to the transfer of shares or restrictions on dividend entitlements, good, bad, leaver provisions, etc. But there's a drafting trap here. One should not include any personal undertakings or specific agreement on the part of the employee to exercise or refrain from exercising rights in a particular manner, because this is tantamount to giving additional new consideration for the shares, and that would count them out as being employee shareholder shares. I'm going to stop there and pass back over to William, who's going to talk about ways in which this might be used.
Thank you, David. George Osborne, at the Tory Party conference last year, ended his section of his speech on shares for rights by saying, 0% capital gain tax. Owners, workers and the tax man all in it together. Workers of the world unite. Has his dream been realised by the new legislation? Well, it seems unlikely. First of all, the application of shares for rights on a wide employee basis seems a remote possibility given the impact of lost employment rights. And also the benefit of CGT value relief is relatively modest given the normal annual exemptions which would apply for most people and mean that the gains were free of capital gains tax anyway. Therefore, I think to find uses for the legislation, one has to look at more specific examples, more targeted awards, perhaps for individuals with less concern about the loss of statutory employment rights. And also, the shares also need to have the potential for significant growth in value. That said, I mean, shares for rights does have substantial attractions. It can apply to companies that are not necessarily independent. You can have some quite flexible arrangements in the context of the terms of those shares. The buyback from leavers can be taxed as capital rather than income. There's the opportunity to obtain certainty as to the value of the shares by a pre-grant valuation agreement with HMRC. The first £2,000 of these shares is tax-free. And that's valued on an actual market value basis, so the potential for some quite low values if the shares are restricted exists. So what sort of scenarios do we expect to see people using these shares? Well, I think the one that has received the most attention is private equity. Here it's envisaged that employees who receive a management incentive scheme involving the receipt of shares with a very low initial value and therefore the potential for substantial capital growth. The low value might arise because the financing structure of the company, large amounts of debt, allow the value of the shares to be low. This could be the scheme could be a very considerable attraction to participants in such schemes. They're normally senior management, and very often they are the ones with perhaps the least concern about the loss of statutory employment rights because they very often have contractual rights in addition. Now, the government was repeatedly told prior to the legislation coming into force that this was the most likely area where this legislation would be used. They were told it, and so one must assume that it is their desire that it should be used in this area. maybe it's intended actually to be helpful to the private equity sector. Because of the ownership structures of many private equity-backed companies, they fail to meet the independence tests which would otherwise allow them to receive EMI or other types of approved share schemes. So maybe the introduction of a scheme that doesn't have an independence test is a concession that's intended for that industry. Government's not, however, said that specifically, publicly. Another scenario where shares for rights is likely to be attractive, and is somewhat similar to the one we just described, is growth shares. They have a similar economic profile to geared shares. The idea here is that you receive an award over a special class of shares with performance targets that are, or thresholds that have to be achieved, which are embedded in the articles. That allows for the shares to have a low initial value, with the prospect, or the potential at least, for substantial growth thereafter. Again, these are normally targeted at senior management, who often already have strong contractual rights, and again, might not be so concerned by the loss of statutory rights. Another scenario where one might expect to see shares for rights used is in the family company arena, where, for example, there might be a non-family manager recruited to drive value. This could be a very effective way of giving shares to such an individual. Sometimes the individual is actually given responsibility for a subsidiary, and therefore the ability to offer shares in a subsidiary could be particularly attractive in this way. Very often an executive recruited on this basis will have strong contractual protections as well, so the loss of employment rights again might not be a huge concern. Not necessarily family companies, but another scenario that could apply are turnaround companies, businesses where there's again a large opportunity for growth, rewarding the incoming executives targeted with turning the business around. Shares for rights might very well work well in that scenario as well. Other possibilities could include situations where, for one reason or another, EMI options are simply not available, or maybe the company doesn't qualify, or maybe there's a potential corporate transaction down the road which might result in disqualification. And so EMIs are sort of high-risk solution. In those situations, either because they're banned or because they're not available or too risky, shares for rights look at an interesting alternative. David's mentioned the possibility that one could award these shares through the mechanism of an option grant. Potentially those could be EMI options. Again, this does seem like a bit clunky way of dealing with things. The complexity of integrating EMI and shares for rights might deter most companies. But of course it does have the advantage that if you grant a nil cost option, the point at which any payment is made required for the shares by the employee could be deferred. Some people have suggested that shares for rights could become the son of profit-related pay. Those of you with reasonably long memories will recall that during the 1990s, profit-related pay was widely adopted throughout British companies. It essentially involved employees agreeing to forego part of their existing remuneration through a pay sacrifice, and then in return receiving tax-free wages which were linked to profit. Very often they received interim payments of tax-free wages, so they were better off after tax than they were before. Needless to say, it became very popular. We don't really see how shares for rights can be used in that way, because first of all, the employee can't give any consideration, so a salary sacrifice isn't really possible. And of course, the employee under shares for rights isn't receiving cash, they're receiving shares, which might be realizable at some point in the future, but might not. So our assessment is that actually it's not only possibly a step too far, but it's probably not workable. Another possibility that people have thought about is the idea of a service company. Now, the idea here might be that you would transfer the employees into a service company, and issue employees with shares worth at least £2,000. The service company then will then be recharge the parent for the employment costs of the employees that they were providing within the group, plus a markup, a margin. And that margin would then help to create value in the company. Potentially employees then could have those shares bought back after they leave with a capital treatment. Is this going to happen? Well, it does involve an awful lot of effort on the part of the company. You'd have to restructure the group. The company would have to give shares worth at least £2,000 at the outset. And remember, the gains that the employee is likely to make in this situation are likely to be relatively modest in a service company. So the actual capital gains tax relief perhaps isn't really that attractive, since the employee would be eligible for it anyway through the nil rate ban for most of the likely gains. And no one's done this already without the benefit of this relief. So the chances are we think that most people aren't going to go for this. Although conceptually it is quite close to the vision that George Osborne outlined originally. Perhaps a more realistic scenario could be the situation in a professional partnership where there's a key employee or employees who are not partners of the professional partnership, which the business would like to incentivize and reward. Now, in quite a few accountancy firms, and increasingly in some law firms, primarily because of assurance reasons or to achieve greater accountability, very often parts of the business are already structured as limited companies under an LLP. And this arrangement, because of the ability to have a subsidiary company participating in the scheme, could offer an opportunity to incentivize employees of those companies. In a sense, what we're talking about here is a variant of the family company use of subsidiaries. Another possibility that might get some consideration is the use of shares for rights or employee shareholder status as an alternative to 0 hours contracts. As we know, there's been a great deal of press comment recently and political concern expressed about the growth of 0 hours contracts. And indeed, I was surprised recently to discover that my own daughter had been a participant in one of these schemes. The essence is that the employee enters into a contract whereby they are not promised or guaranteed any work, but if they work for anyone else, then they lose any prospects of gainful employment with that company. That's either set out in the contract directly, or the employee is made very well aware that that's the basis on which they get any work. Now, of course, for such an employee who isn't really an employee at all, who's just a worker, has no real rights at all, actually moving to an employee shareholder status would be an improvement on their existing lack of any real rights. Plus, the opportunity to get £2,000 of tax-free shares might well be attractive. One does wonder whether this might not be a more politically acceptable way of retaining the other exclusions that 0 contract hours give employers. In order to get the legislation through Parliament, the government had to make a concession whereby an independent advisor is required to advise each participant on whether they should participate or not, or on the terms of their participation. The rules state that this has to be a lawyer or an accredited trade union official or someone from a Citizens Advice Bureau with appropriate abilities. So it's a bit of a closed shop at the moment as to who can give this advice. The relationship will be with the employee, however, fees levels are still to be settled, but ultimately it is intended that the employer will bear the cost of this advice. It's a new area. People will be feeling their way into this, but I think there are professional firms coming forward to give the necessary advice to people who participate. I'd just like to touch on one or two other developments that are sort of associated with these changes. EMI itself over the last couple of years has seen a succession of improvements. We now have a 250,000 limit. Entrepreneurs Relief now is available for the gains on an EMI scheme, and that actually has opened up quite an interesting opportunity, which is that where employees receive shares in their company, if those shareholdings are less than 5% or could be less than 5% when the shares are sold, the smart thing now is rather than to issue the shares directly to those employees, but to issue them through the form of a immediately exercisable option, so that they qualify for entrepreneurs' release because they were originally granted as EMI options. What Shares for Rights has done, however, from the point of view of advisors, has started to sort of muddy the water. It used to be said that EMI was a no-brainer. If a company could set up such a scheme and wanted to reward employees with options, then really it should do so. That was the best way you could think of applying equity incentives. Shares for Rights now created a bit of an alternative, because of course with Shares for Rights the gain is completely tax-free, while under EMI you still have to pay capital gains tax, and you also under Shares for Rights have the opportunity to get £2,000 worth of tax-free shares. So I think in some ways it's going to cause advisors a little bit of trouble, because they're going to have to think about whether their clients should go for SFR or EMI or a combination of the two. And for those who are amateurs in this field, the risks now of giving advice beyond your area of expertise have grown. There have been other developments in the last year as well. There already existed a government-approved scheme whereby employees could make completely tax-free gains. It's the Share Incentive Plan, the SIP. Now, that is very different from the Shares for Rights. It's not a discretionary scheme. It's broad-based. You can get free shares, which again are tax-free, in the same way potentially that you can for £2,000 worth of Shares for Rights. You can also buy shares under SIPs and get tax relief on the cost of purchase. SIPs have tended to be the preserve of quoted companies, but they could apply to unquoted companies as well, and the changes this year in the Finance Act have made them more friendly for unquoted companies. One of the drawbacks that often used to apply with unquoted companies was that if the shares were sold, there could be clawback charges on the exit, both on the employee and the company for NIC savings, and sometimes those could be even more than the original savings when the shares were awarded. Now the rules have changed so that if the shares are sold essentially for cash, the capital gains, the tax-free treatment applies regardless and without any clawback. There used to be some really unhelpful rules about levers applying to SIPs. Those have gone. And another thing interesting that has gone is the material interest test. That's been completely removed for SIPs, which does open up the possibility of what we call founder shares, whereby newly formed companies where maybe the directors and shareholders are the only employees, to at least some part of their financial participation in their business being structured through share incentive plans. JSOPs, which of course were originally developed by members of our team, continue to work, continue to be a very efficient way of rewarding employees where there's growth in value. It applies to unquoted and quoted companies, and as always, valuation is a key aspect in the design of such schemes. Which leads me to one of our final points, which is to do with valuation. And this ties back to the earlier comments about the likelihood that Shares for Rights will be very often used for growth shares. The Inland Revenue has recently made a public statement at the September Fiscal Forum that indicates that they have changed or have reinterpreted what is known as the information standard for share valuation. What essentially was happening was that with growth shares, it was sometimes possible to agree with the Inland Revenue that the growth shares had a nil or nominal or negligible value at the outset. The basis for this was to say that information about the future prospects of the business, because the shareholdings concerned were only a small minority, would be information that would not be available to a small minority shareholder and therefore was confidential and shouldn't be taken account of in any valuation. And that by default meant that the shares for valuation purposes had no value. Now, the Inland Revenue have made clear that they consider that in the past when they have agreed such valuations, they did so in error, and they've indicated that going forward they won't be willing to accept that argument in the future. So that may have some impact on the way people structure and design growth shares and the shares for rights. Those of you who want to be reminded, there is a copy of the book. That's the two-volume leaf updated twice yearly, published by Sweet and Maxwell, and it's now available electronically as well as in hard copy.
William, can I interrupt? We have had some questions to which I can now give the answers. We've had 3 technical questions in relation to the shares for rights. The first is, could the shares qualify for EIS relief at the outset? Which I think the simple answer is no. And the situation is analogous to bonus shares or capitalization issue shares under the EIS scheme, that where no consideration has been given for the shares, that relief would not be available. The second question was, can we use shares issued by an overseas parent company? And to which the simple answer is yes, there is no limit. And indeed, it's perfectly feasible for the issuing company to be a non-UK company. It will, of course, be necessary to check the Articles of Association and the company law of the jurisdiction of that company to ensure that the directors can issue shares, or to see what form of authority must be required for the issue of those shares. But as a general rule, the answer is yes. The third question is entering into a Section 431 tax election properly to be treated as the giving of additional consideration by the employee? I think on reflection, our answer would be no. I think I'd have to take some time to articulate the reasons why, so in a sense that's a gut reaction. But I cannot see that a choice on the part of the employee of voluntarily entering into a tax election to protect his own position against further charges to income tax in the future could be properly taken as the giving of additional consideration for the issue of the shares, particularly where the shares would be issued in any event. Even if it's a term of the employee shareholder agreement that the employee enter into a Section 431 election, I cannot see the revenue challenging that, or and it seems to me that an employment tribunal would give short shrift to an argument that the shares were not employee shareholder shares merely because the employee had voluntarily entered into such a tax election, which, whilst it increases marginally the amount of tax payable up front, in the long term protects him against further charges under Chapter 2, Part 7 of ITPA. So those are our responses to the 3 questions that we've had in so far.
Thank you, David. As I said, if there are any further questions, we're happy to deal with them, but we'll probably have to deal with them individually. If you want our slides and those detailed notes I referred to, then just send me an email. That's my email address, william.franklin@pettfranklin.com. and we'll send those back to you.